Yes, good afternoon, students. I started with the sample recording of part 1. Part 1 was related to the schools of jurisprudence. We had discussed in part 1 the analytical schools of jurisprudence at length. We also pointed out the objective and subjective question on this analytical school of jurisprudence. You see. Today the subject matter is part 2. Today the subject matter is part 2. This is part 2. Now part 2 covers two important schools of jurisprudence. Number 1 is the natural law school of jurisprudence. And the second one is the basic premises of historical school of jurisprudence. This is the second, and in course of discussion, you see, in course of discussion, we will also point out the relevant location of objective question and the relevant, subjective question. Natural law school, if you start with natural law school, if you start with deals with certain universal application of values. It primarily deals with certain universal application of values, you see. These values are the product of these values are the product of moral laws, these values are the product of divine law, these values are the product of law of holy scriptures, law of holy scriptures. These values are the product of right reason, and therefore together this natural law school embodies, the basic principles of morality and natural justice, you see. So the idea behind this school of jurisprudence, to provide a superior base, to provide a superior and actual base to the making of law, you see. Isliye in this connection, it is a kind of superior law, it is a kind of an ideal law which is common to all states, you see, So sometimes it is called jus naturale and jus gentium. Now this is a question, you see. Jus naturale and jus gentium, you see. Now this is a question, you see. Jus naturale and jus gentium, you see. Jus naturale or jus gentium is the product of Roman law, which is closely related to this natural law school which emerged during the 17th and 18th century, you see. These are some superior ideals of law. Which is universally applicable to the state or man-made law, So from jurisprudential point of view, तो यहाँ पर आप देखें एक क्वेश्चन तो ये ऑब्जेक्टिव जस नेचुरल है और जस जेंटियम मीन्स दिस इज अ काइंड ऑफ law, this is a kind of school which is applicable, which has an universal application to all states, you see, universal application to all states. So from jurisprudential point of view, you see, natural law means those rules. Natural law means those rules and principles, which are supposed to have originated from, originated from some supreme source, you see, from some supreme source, and that source is known as ideal source of law, you see. And that source is known as ideal source of law, and which is universally applicable and common to all states. common to all states, you see. So what I am trying to say in this connection, I am trying to say in this connection that this kind of, from jurisprudential point of view, natural law, and a natural law is a, group of certain rules and principles, and which provides a base to, the making of state made law, you see. तो इसका भी एक रोल है, जुरिस्प्रूडेंस में एक इसका इम्पोर्टेंट रोल है, इसलिए इसको, है ना, रोमन शब्दों में इसको जस नेचुरले और जस जेंटियम कहा गया, जस नेचुरले और जस जेंटियम कहा गया। एक तो ये इम्पोर्टेंट स्कूल है। नाउ द सेकेंड इम्पोर्टेंट स्कूल इन दिस कनेक्शन इज, वो है हिस्टोरिकल स्कूल ऑफ जुरिस्प्रूडेंस। द सेकेंड इज हिस्टोरिकल स्कूल ऑफ जुरिस्प्रूडेंस। नाउ हिस्टोरिकल school of jurisprudence, as a matter of fact, this school has adopted an anthropological approach to, this school has adopted an anthropological approach because it is based on the study of evolution and development of law, you see. Evolution and development of law, you see. Actually, this approach is influenced by, this approach is actually Darwinian approach, you see. This approach is actually known as Darwinian approach. Darwin in his book, नाम इसका important है, Darwin, Charles Darwin, in his book Origin of the Species, Charles Darwin in his book Origin of the Species stated the evolution of biological organism, you see, evolution of biological organism. Historical school applied this Darwinian theory. Historical school applied this Darwinian theory into society. Historical school applied this Darwinian theory into society and social institution and social forces. So the basic premises of historical school is that it rejects the state-made law. It rejects the state-made law. It rejects the state-made law, and it also rejects that law is not the creation of nature. Law is not the creation of nature, and or any moral or divine law, and it is not the study of legal history, you see. Actually, historical school examines. Historical school examines the manner and circumstances. The manner, circumstances and factors, responsible for the growth of law, and responsible for the growth of law. So this school takes into account, you see, the study of, the school takes into account the study of, the social forces, and which plays a vital role. Social forces since the primitive period, you see. Social forces since the primitive period, in the process of evolution of law, you see. In the process of evolution of law, you see. So basically, historical school Basically, historical school adopts a Darwinian approach. A Darwinian approach in which adopts a Darwinian approach in which law develops, in the social institution, in the political institution, in the religious institution, in the legal institution. Law develops in the social institution or political institution or religious institution or legal institution. Law actually is the product of the growth of social institution or social forces since the primitive period, you see. Since the primitive period, you see. Now, in this connection, there is an Indian Supreme Court verdict, you see. In this connection, there is a Indian Supreme Court verdict. The verdict, the name of the case title is, that is BP Gariwala versus Union of India. BP Gariwala versus Union of India, and 1991, wherein the Supreme Court, observed, wherein the Supreme Court observed that the Indian legal system is the product of social history. The Indian legal system is the product of social history. It is rooted in our soil. It is rooted and nurtured and nourished in our soil, you see. Our soil, nurtured and nourished in our soil, nurtured and nourished in our cultural traditions, language and traditions, you see. Cultural tradition, language and tradition, and it is reinforced by, and this is reinforced by the gradual growth of, this is reinforced by the gradual growth of cultural and social history, you see. Now, under this head, you see, this school of jurisprudence, the most important exponent in this connection, was the great, Savigny. Savigny, in his book, kindly see the name of the book. Savigny, came forward with two important books, you see. Number one is The Law of Possession. The Law of Possession, and the second is History of Roman Law in Middle Ages. History of Roman Law in Middle Ages. So you see, sometimes you are confronted with certain important statements, you see. Sometimes you are confronted with certain important books also. In course of discussion of, schools of jurisprudence, you are confronted normally, you see, commonly. And that becomes a very important part of, location of, objective and subjective questions also. Savigny, started with, a famous wall, okay, bus ho gaya, Jayist, wall ki Jayist. Now this wall Jayist, now this is a question, you see, 2 minutes. This is a question. Volk Jayist means, the popular consciousness, popular will. So, the historical school of thought, beliefs. The historical school of thought believes, lastly speaking, the historical school of thought believes that in the growth of law, in the evolution and development of law, this popular, consciousness, popular will plays a vital role, और इसी को इन्होंने वॉल के जेइस्ट कहा, vital role is. that plays a vital role, vital role in the evolution and development of law, you see. This is part 2. Tomorrow we will be finishing, part 3, that is Schools of Jurisprudence.